Hello, my lady. Good afternoon. I dealt with diminution in revenue. I dealt with practical workability. We were on general non-denominational policy. And the next submission I make in relation to that is that the approach that says take account of the government's principal position, which is that it provides through the state education system a pluralist, non-denominational option for education in which all faiths and none are respected, is an approach which we respectfully submit chimes with the scope of A2P1 anyway. I touched on this very briefly when I was introducing the case law on A2P1. And none of the parties have particularly focused on the second sentence to A2P1 because that wasn't really the shape of the argument before you. But I wanted to give you one reference into our skeleton below which summarises all of the relevant case law, some of which is in the bundle, but all of the relevant case law in relation to the nature of the obligation under that second sentence. And that references into our skeleton below, paragraph 27, core bundle, page 413 to 414. I'm not going to take you back to it now, but what it demonstrates is that the Strasbourg case law, as it were, sets the limit at indoctrination. You cannot have a state system in which, as it were, the way in which the education is conducted is directly inconsistent in that way, the indoctrination way, with the faith and philosophical convictions of those pupils and their parents who are going through it. That's the core limitation that is provided, and by and large the rest of it is left to the states to organise, particularly if what they organise is a pluralist non-denominational system which has built within it that idea that they will not indoctrinate and therefore will respect the various different faiths or none that might go through the system. And I wanted to take you to a couple, or refer you to a couple of authorities in relation to that, which are in the bundle. The first of them is Lautsi, and I want paragraph 62 on page 1518. This was a challenge to the way in which the curriculum was set up, so slightly different in the facts. But if you look at paragraph 62 at the bottom of page 1518, can I invite you to read, well, really just read the paragraph if you would, and in particular the final sub-paragraph. And to pick up on a similar sort of theme, I mean, you'll see the state is forbidden to pursue an aim of indoctrination might be considered as not respecting the parents' religious and philosophical convictions. That is the limit that states must not exceed. One sees that reflected in some of the case law. So it isn't, as it were, that the parents can choose and that right needs to be respected in the sense of providing education in the way that they want to do it. Indeed, there are some cases, I'll come to one German case in a second, in which they're specifically told to go compulsorily to a particular school which does not conform to the way in which they want to educate their children for religious or philosophical reasons. So it's part of one of the themes that was identified by the Divisional Court, that flexibility in terms of what the state can and can do, particularly in relation to these difficult areas. Just to go back to the judgment of the Divisional Court, if you would, can I invite you to look at paragraph 32, which summarises the Kjelsen and Denmark case, which I'm sure will be familiar to some of you. Page 168 is the page number, para 62.
62 or 32?
It's page, sorry, I'm so sorry, para 32, my lord, which should start Kjelsen and Denmark.
Mm-hmm.
Can I invite you to read that paragraph? Particularly the second half, the aim of safeguarding pluralism and so on. that's a theme you see from Lansing. And if you go on to paragraph 33, X and Y in the United Kingdom, parents complained about the non-availability of selective denominational education following the abolition of grammar schools in their area. See what the Commission decided. Hadn't been denied access to existing educational facilities. I'm reading the penultimate sentence.
This is all about what Article 2 of the first protocol requires.
It is, my lord, and the only reason I'm going here is not to reopen that debate, as it were, but to show the chime with the legitimacy at least of a basic policy that places emphasis and stress on at least the option for all faiths to access the state system, which is pluralistic and non-denominational and is required to respect parents' philosophical and religious beliefs.
But there's a difference, is there not, between the validity of that policy, which is, as you say, chimes with ATP1, and its relevance in this case for religious minorities for whom state schooling would be contrary to their convictions.
Well, my lady, there's a question about that. My respectful submission is that it remains relevant as an option that there is access to. No one is saying, I'm very concerned that we are not to be taken as making the submission which my lord flagged up before the short adjournment, which is that this tends to suggest that you have to go there, and that cuts across your religious belief. If you genuinely feel you can't, you can't. And of course, you recognise that. There's a question of extent and how many are going to be affected and all of that. But there's, of course, a question about that. But my respectful submission is that there is an option available, which is that the state provides education, and then the religious and cultural things are left, as it were, to the parents and the children to pursue in their own time, in their own way, in their own homes, and the education is treated as separate. And I submit that it is relevant, because what you can't do is to approach the Article 14 issues and this policy, in my respectful submission, on the basis that what is in effect guaranteed by Article 2, Protocol 1 is I know you're not coming at it from this position, but is as it were a free choice that the state then has to facilitate or allow. What the case law actually shows is that the Strasbourg court has said if you set up a system in which you are operating a pluralist, non-denominational set of state education, that is sufficient. And it may even be sufficient in circumstances where the child under your domestic law is compelled to go there in circumstances in which the parents, for religious reasons, would much rather have them at home being subjected to the religious and cultural belief systems that the parents hold. Those are the facts of the Conrad case, which you see referred to in the Divisional Court's judgment at paragraph 41. And you get a bit of a sense of it from paragraph 41, which I respectfully submit is an accurate summary, and I hope very much bears out the submissions I've just been making. You might want to note next door to paragraph 41 that you do have it in the bundle, Conrad. It may be quite an important or interesting case to have a look back at for this purpose. And it's tab 49, page 1458. And the key bits are really at 1462 to 1463. But the summary for present purposes will do in paragraph 41 of the Divisional Court's judgment. So the government's principled view here was that it was important, as it were, that that option existed for all children.
Yeah, I don't want to dwell on this, Sajid, but this is a point against you. It may in fact be a point in your favour, I don't know. It depends on under what rubric you invoke this. All I was saying before the short adjournment is that this wasn't one of the 4 aims of the policy. So when one is asking for what is the aim of an alleged interference with an Article 14 right, this wasn't one of the aims. When it comes to how you achieve those aims, you're perfectly entitled, at least it seems to me, to point to a number of different things which bear upon the means by which a state achieves its aims. One of which is oh, you already told us, raising the need to prevent abuse, administrative workability, cost, and so on. Well, one gets all of those points. And in that context, you're perfectly entitled to point out, as part of the proportionality analysis, and by the way, in principle, people do have access to the state system.
Yeah.
And the state system is not doing anything improper under the convention when it has this pluralistic approach to state education. All of that I get. What I was slightly...
You were querying was the aim.
Yeah, and whether it starts to become a legitimate aim to say we positively want to end religious education, for example. And you're not saying that.
I'm not saying that.
That isn't the aim.
No.
If this VAT change had been made with the express purpose of closing religious schools, for example, I think this case would have been a completely different kind of case, and your arguments would have been very different. But that's not what you're mounting as a defence.
My lord, I'm sorry if I misunderstood it. I was worrying that you were quibbling why we were going here, or asking why are we going here at all.
No.
I don't really mind where it comes into the analysis, as long as it is legitimate to go there, because the divisional court did attach some importance to it. You can argue whether or not it falls within the concept of fairness narrow or fairness broader in those aims generally. But for my purpose, it doesn't matter. It's also, to some extent, blurred in to the question of approach that we were discussing before the short adjournment. And you will recall, it's perhaps a reference I should have given you earlier without wishing to divert too far from the point I was on, but you'll recall that in 129 of the judgment, just briefly flick back to that. I mean, really the reason for going here is because the divisional court says, well, you need to look at what you need to justify under Thelimenos. It's the lack of a differential treatment. And then they say, in other words, the uniform nature of the rule or the absence of exemptions, rather than the policy in some broader sense. But again, you can see that the dividing lines become extremely thin, because if you're justifying a uniform policy, you are in effect trying to justify why you don't have any exemptions or cutouts from it. So it comes to roughly the same thing. So I don't mind which stage you get to this point under, but I do submit that it is relevant in the proportionality analysis, if I put it broadly in that way, to take into account that the state's principled view is one which favours the fact, as they see it, that the state system that they provide is deliberately designed to ensure that it's pluralistic, non-denominational, say for limited exceptions, and that everyone's rights to religion and belief are respected. And that is important, because you could have a situation, to a greater or lesser extent, in which a group or a group of individuals, be they evangelical Christians or Haredi Jews or whoever it may be, where they strongly object to that. And of course one understands that, but the option remains of accessing education in an environment which is designed, and which the state wishes to promote, as it were, designed to respect the views of all faiths and none.
So, I mean, your answer to the direct criticism that is made of the divisional court is that it was right to allocate in the proportionality exercise considerable weight to the plurality policy.
Yes.
And notwithstanding the finding that to these Haredi Jews, such an education was directly contrary to their principles.
My lord, yes. We submit that they were entitled to place reliance on that, because it exists as an option. Yes. And it's I don't want to get into
No, I just wanted to be clear, because that's, anyway, to me, seemed at first sight a reasonable criticism. But you say, no, it's not a reasonable criticism. It is, as part of the proportionality exercise, one is entitled to look not as an aim of not having an exception, but it is part of the very important background. So
and if you will, mitigation. Now, it may apply to a greater or lesser extent to particular groups, of course one acknowledges.
And it goes directly to the question of whether or not there ought or should or could have been a suitably drafted exemption, because you don't, if your policy is to have pluralism, non-denominational schools for all faiths and none, then an exemption is difficult because it's directly contrary to that policy.
Yeah, that's one of the reasons why it's difficult to draft the exemption in that way. But my lord, yes, so we do respectfully submit that 156 stands. And of course, I don't want to get, again, it'd be invidious to get sucked too far into precisely how far the divisional court went. But the central criticism, which I ought to at least to try and address, is that, well, that's totally inconsistent with what they found in 149. My respectful submission for the reasons of principle that we've just been discussing is that it isn't. It does represent an acceptable state option, viewing the state education system as a whole, and as it were, the religion and their religious beliefs can be respected in that system and at home. And no one is seeking to interfere with that, and the limits of A2P1, as it were, is directly consistent with that. Indoctrination is prohibited, but everything else is not, as it were, if it's a pluralist system. Even compulsion to go there, see Conrad. But you will see in 149, just to be fair to the divisional court, if I may, I mean, you will see in 149 that they do, those first 2 points do tend to hang together. They fully acknowledge that they do not have state alternatives which are religiously acceptable to them, and they cast that as a result, as it were, of the first point, which is cast in terms of having strong religious or cultural preferences for a Haredi education. So that is the way in which the divisional court looked at it, and I respectfully submit that that is an appropriate way of looking at it. Just to pick up one point on anti-Semitism that my learned friend raised, again, I'm not going to start quibbling with the evidence, and there was evidence in relation to Jewish people, there was evidence in relation to Muslim children. There is no doubt that that sort of behaviour exists in fact. But it is not, and under the state system would not be, a tolerated form of behaviour. It is poor behaviour which the law deals with in a variety of different ways, and which is not acceptable, and no one suggests it's acceptable. Schools could not permit or facilitate that sort of behaviour. It would be totally inappropriate for them to do so, probably unlawful for them to do so. And indeed, not merely that, but the risks of anti-Semitic behaviour, with all the appalling nature that that entails, was acknowledged as a fact in the judgment of the court by reference to that evidence. And so the divisional court, just to give you a reference, in Annex A to their judgment, at paragraphs 7 and 9 of Annex A, when summarising the facts of the various schools and school claimants and so on, specifically picked up and made reference to the fact of anti-Semitic behaviour having been suffered by some of the children concerned. But it doesn't undermine the basic validity of the state's position, which is we have an education system which is pluralistic, non-denominational, and in which that sort of behaviour, and indeed any other behaviour that would amount to not respecting someone else's faith or cultural beliefs, is not permitted. So that's the third point. The fourth point we've touched on already and goes to the extent or likelihood, because, as you know, the exemption which is called for is a low-cost exemption. I've made all the points about that extending well beyond Haredi Jewish families, if that is the nature of the exemption which is contended, or the non-creation of which is contended to lead to the declaration of incompatibility. But there are a series of questions which mean that it will be very difficult for the court to proceed on the basis that these impacts are going to be, or are indeed even likely to be, faced by very large numbers of people. I mean, you have got all of the matters already that nuance that as a suggestion. I mean, you've got the fact, as I described it before, the short adjournment, the laudable fact that this community sets particular store about supporting children and schools that educate in the faith. There is a serious question as to whether or not any schools would in fact be likely to close. It comes down to individual pupils. There will be some pupils who can afford to continue to pay the fees even with the VAT added on, to the extent that's passed on by the schools. You will have perhaps some who can't, but it won't be all of them, and they may attract support from the community to enable them to go through. One simply doesn't know. So there is a whole question about the nature and extent of the effect that the introduction of the new rule without an exemption would create. And it can't just be assumed it's going to affect everyone in the community and all of their children. You also have the point already that there is the possibility of a movement, albeit over time, and albeit this is not suggested as an immediate solution, but there is the possibility of movement from the private sector into the state sector as a faith school, in effect. That ties into the points that the divisional court made about the delicacy, as it were, and the fairness implications of making a special cutout for a group of schools who had these very significant or some significant difficulties in complying with the relevant standards. That's the point at 157. There is the possibility of movement from private into state in that way, whilst preserving that ethos, that religious teaching and that philosophical approach. And there is ultimately the possibility of homeschooling. Under our system, that is not a prohibited option. No one suggests that it is optimal or ideal, but that possibility exists and is taken up by significant numbers of people. And under our domestic legal system, homeschooling is not just leave it to the parents. Homeschooling comes with a set of obligations on the parents to ensure that the education that the child received is in fact received and is appropriate. So all of those possibilities exist under domestic law. And again, all of those things go to the appropriateness or otherwise, along with all the other matters that I've already identified. They all go into the melting pot, and a judgment then has to be made. Has a sufficiently powerful case been made for cutting out an exemption? And we respectfully submit on the basis of the factors so far that is both intensely problematic and we respectfully submit it is justifiable to have a more general rule and there is no requirement under the Convention or Article 14 or otherwise to cut out these sorts of faith schools or low-cost schools in a way that would give them more favourable treatment. That leads to the final point, and the final point is the wider implications of singling it out. And again, to some extent, these aren't hermetically sealed categories, because we discussed before the short adjournment whether you could just simply say, well, don't worry, it's all about raided Jews and the rest can be sorted out by Parliament. My submission, as you know, is that you do have to look at the reality of the position. You're entitled to test the logic of it. How is it meant to work if you single out these exemptions? And to some extent, the difficulties of doing that, quite how that would work, quite what logic that creates, how far that then flows into other areas that might undermine or create difficulties for other parts of the general justification for the measure, are all difficult questions. The divisional court grappled, we respectfully submit, fairly and directly with these issues, and they did so in particular by considering how you might frame an exemption. They did it in 151, they did it in 152, in particular considering whether you could do a much more narrow exemption applying only to already Jewish schools only. And you see how they treated that. And those are all genuine and fair points to make about the the principal difficulties of just restricting it in that way, and then they come back to it in 158 in particular. And again, as I understood it, my learned friend appeared eventually to accept that this sort of argument was indeed relevant to the issue of justification. That's obviously right. You plainly need to consider the logic of the exemption for which you contend. It extends as far as it extends. You can't just restrict it to why not accord preferential treatment to a subgroup that might lead to a much broader exemption. What if the subgroup is 2 people and the exemption will cover 100? And the 100, or the 98 that comprise the 100, are not in any way, as it were, affected in the same way as those who are the 2. But my submission is that in principle you need to consider it across the range of coverage, and it also prompts a series of legitimate questions going to bright line, general rule, or an exemption, legitimate questions about why one group and not some other group. Why are schools costing less deserving of this treatment? And so on. Difficult indeed, we submit, coherently to single out those who are left in this appeal from lots of those who've dropped away, as it were. We're simply left with the evangelical Christians and the Haredi Jewish community, but there were below, as you see from the judgment, a much bigger cohort of people who are being said should be the subject of these exemptions. But it does threaten the unravelling of the general justification if you start cutting that out. And there are good reasons for saying, well, we'd much rather stick with the general. The court was interested in the evidence or the position in relation to for example, others, and so far as that is concerned, I know my learned friend Ms. Hannett may pick up some of this, but I suspect for my purpose you get probably most of what you need from the judgment itself. You can see that very similar points are being made by the Muslim community. You see that very similar points are being made by the evangelical Christian community. It's not at all difficult to see how, if you take into account all of those people, you suddenly get into a place in which someone says, well, the convention requires equal respect for philosophical conviction as well as religious conviction, and those people have to come in, and all of that has to be mapped against the only exemption game in town, as my learned friend Mr. Broach confirmed, which is the assertion that the legislation is incompatible because it doesn't create an exemption for low-cost schools with all of the coverage that entails. That leads to the final point I wanted to make, which is under this, which is, I think, number 4 or 5, which is that ultimately, I'm sorry to harp back to this, but ultimately, as indeed was the punchline of the Divisional Court's judgment at 159, these questions, and by these questions I mean the sort of questions raised under each of the 4 or 5 heads I've been addressing you on, and the interrelationship between all of them, these questions are not questions that admit of one right or wrong answer. There is sufficient to provide proper, reasonable justification for the general submission, for the general position, without exemptions, is my submission. But these are ultimately questions of legislative judgment. And not merely are they questions which are in principle of legislative judgment, but they were specifically considered, or much of this was specifically considered. I don't want to go back unnecessarily to the government's consideration of all of this, but there are in the bundles a variety of ministerial submissions which specifically consider the position of faith schools and specifically consider whether or not a low-cost exemption or some other form of exemption should be taken forward and promoted in Parliament or put before Parliament as an option. Can I just give you references to 2 of those ministerial submissions and their paragraph numbers as a flavour for governmental consideration of this? The first is the ministerial submission of the 24th of September 2024 in Supplemental 2, page 698. See in particular paragraphs 8 and 9, rejecting calls in effect for a faith school exemption, and Annex C to that ministerial submission, and see further the ministerial submission of the 8th of October 24, supplemental 2, page 709, and if you go to Annex D, you will see a section headed State Sector Viability, which may be worth a bit of a read. But it fairly said, well, that's government. Government thinks about legislation carefully before it puts it before Parliament. What really matters, in accordance with the well-known reasoning of Lord Reid in SC, round about the paragraph 180s, I think it is in SC, that section considering parliamentary materials. This was, and by this I mean the very exemption which is now being called for, was specifically put before Parliament and rejected, as the Divisional Court found correctly in paragraph 159. Sorry, I gave you a reference earlier to their punchline being 159. That should have been their punchline being 160. But 159 is the opposition day motion point. And you can see that the very exemption which you're concerned with was specifically before Parliament and rejected. I spent some time trying to track down that debate in the bundles, but if it helps, it's not that easy to do it from the witness statements which refer you to exhibits, and you've got to go to the index and try and make it work from there. But the reference to that opposition day motion, what was being suggested, you will find in Supplemental Bundle 2, page 840, right-hand column. It's not too specific, starting about 10 lines down. And of course, that fact is of considerable importance. Can I just invite you very briefly to go back to Lord Reid in SC, tab 33, page 828 in the authorities bundle. I just invite you to read 182 so you see the principle. And in effect, what is being said in that paragraph is that it's the fact that Parliament considered it that is important. So of course, ultimately, you've got to judge the legislation on its effects, but it is a relevant consideration that Parliament formed the judgment that it did. That's really the passage between A and B on page 829.
I think, Sir James, we also derive two propositions from this, don't we, which we need to be careful about. One, we as courts cannot engage in assessing the quality of the...
That's 183 specifically says that.
And secondly, the fact that it hasn't been considered doesn't count against...
No, it's a bit of a one-way street from our perspective. But it is relevant that it was debated and they decided not to do it.
But relevant but not dispositive.
Relevant but not dispositive, of course. But relevant and helpful to me, if I can put it that way. And you'll see what he says in that respect in 185 as well, if you're in that section still. And as I said before, we're making submissions. I referred you earlier to 206 to 208 of this judgment, but it is perhaps now we're here worth ending on those, because you can see how they actually went about applying all of this margin and taking into account parliamentary debates and whether or not these were judgments of a particular kind, and is there a legal yardstick by which you can start assessing and weighing all these difficult policy issues in the pan. And you see ultimately how they do it. If you just pick it up at the bottom of, pick it up between B and C on page 834 within 206. how far the welfare system should go to protect families against the vicissitudes of life is a matter on which opinions in our society differ greatly and of which Parliament is the best judge. And then if you drop to 207, and you'll see the way they're analysing the issues in that case, which was about the two-child rule. You only get benefits for two children, not above, as it were. But look at the back end of 207, just above the letter G, the line above the letter G on 834. Parliament was told that reducing spending on welfare benefits would allow the government to protect other expenditure of benefit to children on education, childcare and health. Furthermore, the difficult question is not so much what would be in the best interest of children, but the extent to which it's fair, economically desirable and socially acceptable to impose the cost of supporting children if parents lack the means to do so themselves and other members of society. Parliament must have considered the impact of the limitation upon the interests of the children who would be affected by it was outweighed by the reasons for introducing it. The assessment of proportionality, therefore, ultimately resolves itself into the question as to whether Parliament made the right judgment. That was at the time and remains a question of intense political controversy. It cannot be answered. See the echoes to Lord Justice Legate's reasoning in the Court of Appeal, which I showed you earlier. Cannot be answered by any process of legal reasoning. There are no legal standards by which a court can decide and so on. You can read the rest for yourself, but 208 is important because it was ultimately the dispositive feature in that case. That was ultimately what held sway. You see the reference to manifesto commitments and so on in 209, but that's what did it in SC. And it's illustrative, not dispositive. Margin is only a tool and all of that. I accept all of that. But when it comes to it, those sorts of legislative judgments should, I respectfully submit, be left to Parliament. And we are in that territory here. Well, my lady, I was going to hand over to Miss Hannett unless there were further questions you had for me.
Yes, thank you.
Great.
Ms. Hannett.
My lords, my lady, I'm going to deal with three issues that relate to the evangelical Christian appellants only. First is the argument advanced in respect of direct discrimination. That's ground 7.
Sorry, can you just keep your voice up a bit? Sorry.
Of course,
Three issues.
The three issues. The first, my lord, is the C3 claimants' argument on direct discrimination.
Yeah.
That's their ground 7, and it's paragraph 2 of the government party's respondent's notice. That's Corp envelope 144. The second issue is the first paragraph of the government party's respondent's notice, that instead of assuming the point in the evangelical Christian claimants' favour, the divisional court ought to have concluded that they were not in a relevantly different position from others for the purposes of criminal discrimination. And the third issue I'm going to address is a very small number of proportionality points that have been raised, particularly in that context, to the extent that they haven't already been addressed by Sir James today. So if I start with the first issue, direct discrimination. We deal with this in our skeleton argument at paragraphs 26 to 28. And by this ground, Mr. Quinterfell contends that the measure directly discriminates against his schools, as they're required to account for VAT on the fees that they charge, whereas academy schools, which are state-funded independent schools, are not required to account for the VAT. That point wasn't addressed by the divisional court. It didn't, I don't think you need to turn it up, but it didn't appear in the list of issues, which was an agreed list of issues, which features in the judgment at paragraph 7. But in any event, as you see, we've set out in our respondent's notice why we say that this argument ought to be dismissed now by this court. So, in respect of the argument as it turns on fees alone, we say first that academy schools and independent schools are not in an analogous or relevantly similar position for the purposes of Article 14 for at least two reasons. First of all, academy schools do not charge fees to provide education, and indeed they're prohibited from doing so as a matter of law. For your reference, the note is section 1, subsection 9 of the Academies Act 2010. That's in the authorities bundle at page 72. In fact, academy schools are wholly funded directly by the Department of Education. In contrast, private schools are permitted to charge fees, and of course they invariably do so. So we say they're just simply not an analogous situation because there are no fees charged by academy schools for services to which VAT could be applied. The second distinction is that, contrary to my own friend's submissions yesterday, academy schools and private schools aren't an analogous situation in terms of ownership and control. They are both independent schools, but academies are subject to significant state control via funding agreements, by which the Secretary of State imposes a number of obligations on academy schools, for example, as to the nature of the curriculum, exclusions, school meals, etc. And if an academy school fails to comply with those obligations, there are a series of measures that the Secretary of State can take. And there isn't a similar regime in respect of private schools. But in any event, even if one was to assume that a private school and an academy school are in analogous positions, there are at least two other issues in the analysis. First, if the status must necessarily be being a private school, and if that does amount to a status for Article 14, assuming that for these purposes, then a difference in treatment would require little by way of justification. It's not a difference in treatment on the basis of religion, so not a difference in treatment on the basis of a suspect ground. The measure applies generally to all private schools, whether they are a faith school or not a faith school. Further, any difference in treatment is obviously justified. Taxing private schools raises exchequer yield for all the reasons Mr. James has already outlined today. Taxing academy funding would be an entirely pointless exercise, as the funding comes directly from the state. Yesterday, my own friend's argument on this point developed a little, and he referred not just to fees alone, he also referred to the fact that academy schools are allowed to charge fees on where they are a state boarding school. Fees may be charged to parents. And also they're entitled to charge on matters ancillary to the provision of education. And they're not required to account for VAT on either. As a matter of generality, neither point form part of his pleaded case. The challenge there is squarely to the imposition of fees. Just for your, can I give you just the references? The claim form refers to fees alone, that's Core Bundle 542. Statement of Facts and Grounds makes no reference to boarding schools at all, and it refers to matters ancillary to the provision of education in passing only. The references are Core Bundle 555 and Core Bundle 581. So the matter's not pleaded. As to boarding schools, it's difficult to see why this is relevant. None of the C3 schools are boarding schools. They're all day schools. So none are affected by this difference in treatment. In Human Rights Act terms, none are victims of any difference in treatment. As to the imposition of VAT on ancillary matters, the position is a little more nuanced than presented by Mr. Quintaval. I just show you the technical note which summarises the legal position in terms of the application of VAT, just so that the position is clear. It's a technical note. It's in the supplemental core bundle at Harris 2.13 to 2.1. Sorry, start again. It's pages 334 to 335. Supplementary core 334, and paragraphs 2.13 to 2.14 set out, and over to 2.15 in fact, set out the circumstances in which VAT may be charged on matters ancillary to education. And the court will see that in fact, save for boarding, those matters that are closely related to education remain exempt from VAT. See that from paragraph 2.13.
Yes, there was reference to things like music lessons. There would be a difference in treatment there, I think.
There will be some. You can see, my lady, at paragraph 2.15, extracurricular clubs that are not educational in nature. I think the answer to Mary's question is there are some. The situation is quite nuanced, and it may depend precisely on the circumstances. But the way that it was put by my learned friend yesterday tended to suggest that all of these services were now subject to VAT, and that simply isn't right for the reasons set out in the technical note. I don't think it's necessary to go into the precise ins and outs of it, but the broad position is summarised there. But in any event, it's not really clear where any of this takes C3 appellants. As I understand it, it's no part of their case that the imposition of VAT on matters ancillary to education affects affordability or the likelihood that the children will be displaced into the state sector. Indeed, the entire point of extracurricular activities is they are just that, extra to the education being provided. No school has to provide them. No child has to access them. So it obviously doesn't impact the school's viability for the purposes of A1, P1, or a child's ability to access the school for the purposes of A2, P1. So for all of those reasons, however the case is put, whether it's put on fees alone, or whether it's put in respect of boarding fees or in respect of matters that are ancillary to education, none of those matters in our respectful submission get close to mounting a direct discrimination claim under Article 14. So, my lords, I mean, that's the first point. The second point is the respondent's notice on differential treatment. And the judgment at paragraph 175, let's go a step back. At paragraph 174, the divisional court accepted that the evidence of the particular claimants in this case was such that they were unlikely to regard as acceptable in the education based on the state sector. Went on to say that the claimants have to go further than the facts of their case and show that evangelical Christians as a group are in a relevantly different position, or that they're disproportionately prejudiced by the challenge measure so as to found a claim of indirect discrimination. And paragraph 175, although they expressed some doubts about whether that could be said of evangelical Christians, they were prepared to proceed on the footing that there is some relevant subgroup into which the claimants fall. Just before making my submissions, may I just contrast that with the position in respect of the Muslim children, which is at paragraph 165 to 166, where the divisional court accepted the evidence presented by the particular claimant, A or V, who went on to say at paragraph 166 that the material relied on didn't supply evidence for the contention that Muslims as a group are more likely to find themselves in this position than others. And they went on to set out a series of factors as to why that was. And broadly, we say that those reasons apply just as much to the evangelical Christian claimants as they did to the Muslim claimants. And the evidence in respect of the Christian claimants exposes the same flaws, and I'll develop those reasons in a moment. Before I set out the reasons why those apply just as much to the evangelical Christian claimants, my other friend yesterday appeared to accept that he didn't have to show group disadvantage for evangelical Christians as a group. And he didn't set out to dispute points that I'm about to make. Rather, he put his stall effectively on the fact that he didn't have to make good that premise at all. So what I propose to do is just explain why the government parties say that the Christian claimants don't meet the test that we say is correctly set out by the divisional court, but then go on to explain why Mr. Quintaval is wrong to say that he doesn't have to demonstrate those matters. So, 3 reasons why we say that the evidence just doesn't establish group disadvantage for evangelical Christians. First of all, there's no evidence before the court that Christian parents or evangelical Christian parents are, as a cohort, more socially disadvantaged and thus disproportionately less likely to be able to pay school fees following the imposition of VAT than all other private school parents. That's the first point. Second point is that there's just nothing before the court to indicate that in what proportion of cases Christian pupils or evangelical Christian pupils who are no longer able to afford their school would have a state sector alternative that they regarded as acceptable. So while the divisional court accepted the evidence of the particular claimants in this case, that they are unlikely to regard any state sector alternative as acceptable, there wasn't any evidence before the court as to the position of Christians or evangelical Christians more generally, and whether they would view what was on an offer in state schools as being unacceptable for their faith needs. And we say that was a particularly important issue, given that there are a very large number of Christian state schools. I'll just show the data on that. It's in the supplemental reference bundle at page 342. And I apologise in advance, this data is extraordinarily tiny. But to the extent I have to lift my glasses to see it, but what one does get when one looks at it, one looks at the, take for example, state-funded secondaries, which is in the left-hand column about halfway down, follows that along. State-funded secondaries, there are about 200 Church of England secondary schools. There are also a number of Anglican schools and other Christian faith if you follow the top along a little bit. One can make the same point about primary schools and the various variety of state-funded Christian schools. But the punchline on this really is that there are a very large number of Christian state schools with different Christian denominations, and there isn't any evidence to show that Christian parents, or evangelical Christian parents in this private sector, what proportion of them would regard state alternatives as unacceptable. The third point is that some of the C3 claimants say that they're disproportionately likely to be deprived of an education if they can no longer afford private school fees because their parents will not send them to school. See, for example, witness statements at Mr. White at paragraphs 46, 47 at pages 91 to 92, and Xansa, paragraph 40, page 101, supplementary bundle. But to echo the submissions that have been made by Sir James this morning, home education, of course, is an option in those circumstances. Section 7 of the Education Act 1996 requires parents to cause their children to receive full-time education, either at school or at home. And if parents fail to do so, there are a series of steps that can be taken under the Education Act 1996 to compel them to ensure that their children receive an education either at home or at school. And the government parties say that to the extent that a parent doesn't cause their child to receive education once they've been removed from the school, that isn't a failure of the state, it isn't a difference of treatment that the state is responsible for. So for all of those reasons, the government parties invite this court to conclude, the divisional court ought to have concluded, that the evangelical Christian claimants hadn't established that they form a group whose situation is significantly different from those attending private schools more generally. Now, as to what the claimants have to show, the position of the C3 claimants appears to be, under the skeleton argument from yesterday and the submissions that were made, they don't have to show any group disadvantage, that that's not required, they say under Article 9, and or by analogy A2P1, and that if the individual rights of the claimants have been infringed, that amounts to a complete answer to the claim. The difficulty with that is that the Article 14 status pleaded by the claimants is that of being an evangelical Christian. And indeed, as part of their grounds of appeal to this court, they seek to rely on the increased scrutiny that that status, i.e. the religion, purposes of Article 14, and that it's a suspect ground, is said to afford. And therefore, what they need to show is that the reason that their situation is significantly different, and that the reason they ought to have been treated differently by the state, is by reason of their status as evangelical Christians. In other words, they have to link the reason for claiming different treatment with the status that's pleaded, i.e. evangelical Christians, religion, and so on. We say the reasons I've already set out. The evidence simply doesn't establish that in this case. Well, as I was going to turn to the third and final point, which is justification. In respect of Article 14, the divisional court took the same approach in respect of the evangelical Christian pupils as it did to the Jewish pupils. One can see that from paragraph 176 of the judgment, where they applied the same combination of practical and principal reasons applicable to the Jewish pupils to the evangelical Christian pupils. And for the same reasons that Sir James has already articulated, the justification is effectively made out in respect of Article 14. There are three particular points that my letter friend took on his feet. First of all was that there hadn't been any assessment of the inability to pay. As I understood it, particularly of his clients, but perhaps that was also a point made more generally. Second, he relied on court fee pay, the cases concerning court fees as being analogous. And then third, he made a number of points in relation to the ways in which the difference in treatment might have been made for evangelical Christians or claimants more generally. I propose to deal with each of those points in turn. The first is that there was no assessment of the inability to pay. The divisional court dealt with this point at paragraph 120 in the context of justification for Article 2, Protocol 1, and less intrusive means and fair balance. And they dealt with this point specifically as fair balance. So if I can just invite you to read 120. The underlying, I propose just to give you the underlying references for the evidence from where those points come from. That comes from Graham at paragraph 96, which is Supplementary Core Bundle 265. Same point is repeated in the summary of responses to the technical note at paragraph 5.11. That's a Supplementary Core 296. The 90% of families having a household income of more than £50,000 is from the witness statement of Ms. Robinson at paragraph 22, at Roman 2, Supplementary Core at 36. None of that material is referred to in the C3 claimant's skeleton argument, or indeed was engaged with by my learned friend on his feet. It doesn't make any reference at all to that part of the divisional court's reasoning or the underlying evidence, or explain why the analysis of that constitutes an area of law. But the point is that it was apparent, as the divisional court say, that it was squarely before Parliament that the imposition of that would well lead to some individuals being unable to afford fees, and that was a matter that was made clear to Parliament and was clearly before them. The second point in terms of proportionality and justification concerns the court fee cases. My learned friend sought to draw some analogy to court fees and to the suggestion that in particular cases of Unison and Julian and Estonia, to provide that domestic law, which provided domestic common law and under European Convention of Human Rights, there can be no absolute obstacles to access to a court, and any limitations on the right of access to a court falling short of absolute obstacles must be justified and proportionate. It's not really clear, respect, where that takes the court in this case. Those, of course, are cases arising in a different context, concerning different facts, and indeed different provisions of the ECHR. Here, by contrast, the claimants aren't being prevented from establishing, running or attending private schools. There's no absolute obstacle in the language of Unison and Julian to them doing that. But in essence, the reasoning, to the extent it applies, is analogous really to the arguments that have already made in respect of NPP. Does it impair the very essence of the right? Does it prevent one accessing the right? And for the reasons that have already been given by Sir James, we say, of course, that doesn't apply on the facts of this case. The final point on justification is that my learned friend, Mr. Quintafar, made a number of points about less intrusive means, in other words, ways in which a measure may be adopted to provide difference in treatment for the evangelical Christian clients, or adapted in ways for a wider group of claimants. The first is that he talked about an exemption or a rebate and referred to one form of exemption that he said was already applicable, namely the music and dance scheme. That wasn't a point taken below. And for that reason, a further witness statement, Ms. Whitehouse' second statement, has been lodged to explain circumstances in which the music and dance scheme arises. Her second witness statement is in the supplementary reference bundle at pages 948 to 952. But the punchline basically is it is not an exemption to the VAT scheme. Specialist music and dance schools still charge VAT on their fees. A number of children who attend those schools do so with a bursary or an award to cover those fees from the Department of Education. And the Department of Education, in some cases, has increased the bursary or the award to reflect a proportionate increase in fees that charging VAT has caused. We say it's not an exemption to the imposition of VAT. It's merely, and it's an existing scheme which has been modified to reflect the fact that fees in some cases will be slightly higher. Second suggestion my friend made this morning was that there ought to be a discretion for the Secretary of State to consider individual applications. That's not a point that's been raised previously. It's plainly unworkable. Third is that funding should come from general taxation, not via the imposition of VAT, so that only those who can pay do so. Again, that's not been suggested previously, but it plainly wouldn't raise the revenue that's contemplated by the amendments under the Finance Act. And it isn't the scheme that Parliament has chosen. And finally, my friend referred to a low-cost exemption. Again, Sir James has dealt with that at some length this morning. I'm not going to repeat those points. But those points we say apply equally to the manner in which the point has been put by Mr. Quinterval, the way in which it's been put by the Haredi Jewish claimants. So, Lord Melly, unless I consist further, those are the additional points that I wish to make.
Very much. Right, who's going first? Mr. Birch.
My lords, my lady, I go first. Very quick. Lords, my lady, may I begin by starting with the Master of the Rolls' question this morning as to whether the court would need to be satisfied that there could be a workable exemption for the benefit of my clients. We absolutely agree that this court must live in the real world and look at the exception contended for. We do say the proper question is, has the government satisfied you that there isn't a workable exception? So it is a substantive question, Lord Justice Singh posited, but we do reiterate that the burden of justification is on the government, and that an exception having been put forward and considered, we say that the government hasn't discharged the burden of showing that it's unworkable or otherwise justified not to make it. We do emphasise that relief in the form of a declaration of incompatibility would not require Parliament to adopt the low fee exception as proposed, or indeed in any other form, or indeed to do anything at all. Parliament would note that the failure to treat the Haredi Jewish community differently had not been justified, and could be expected to consider this plausible solution. We agree with the Divisional Court's characterisation of Para 154, but could also consider any other solution anyone wishes to put forward, including the Executive. We do say that this proposed solution is a good proxy for the particular group whose needs justify an exception, the Haredi Jewish community. Two references, if I may. First of all, to 288 in the supplemental, the second supplemental bundle, the reference bundle. This is to the email that sets out the analysis on the proposed exception. And we see at paragraph 12, we have found a few small Jewish schools with fees above the threshold. So there's perhaps a degree of under-inclusiveness, but it's only a handful of schools that Jewish schools that would not qualify. The option also carves out some non-religious schools, paragraph 13, but the large majority of the schools excluded by this option are religious schools, Muslim, Haredi and Christian schools trust, in descending order. There's a little more about that at page 719, which is the reference that Sir James gave. We just look briefly at that. In the annex to one of the submissions, and we see a table at the bottom of 719, which shows a selection of faith schools which typically charge lower fees, including fees below the average per pupil cost for state provision, which of course is the number that's been used. We see it would be 65 in the UK schools, around 20,000 pupils, all of whom charge less than that figure. A large number of Muslim schools, a roughly equivalent number of Muslim pupils, where only a handful of schools charged over that number, and a much smaller number of Christian schools and Seventh-day Adventist schools. So the measure is somewhat over-inclusive, particularly in relation to the Muslim community, but we do say it remains the most plausible solution, and that this over-inclusivity is not a weighty reason not to adopt it, but that would of course be a matter for Parliament to respond to any declaration of incompatibility. Could I then give two responses to issues raised by my Lord Justice Singh in opening? One was on the point of the evidence that schools will close, and of course the key point is that it's very early days still, but we do have the statement from Mr. Pearl in relation to my client's own school, which is at the very beginning of the first supplemental bundle, pages 4 to 7 of that bundle, and in particular paragraph 7, which summarises the position and essentially says that there's a real risk of closure. So that's the evidential basis, and that closure is a very real possibility at the end. We then, of course, have Mr. Pinter's data on the financial vulnerability of the schools generally. That's page 290 of the reference bundle, and we would respectfully adopt my lady's analogy of the straw which breaks the camel's back here. These are very vulnerable schools. The government has recognised this. See page 535 of that bundle, which we went to in opening. Also page 726 of the reference bundle to which Sir James referred in relation to smaller schools generally.
Did you say 726?
Yes, my lady. So that was 535 and 726 for the government's evidence. And just to note, Mr. O'Doherty's statement, the new statement of 1028, is about private schools generally, not low-fee faith schools. That was the first point. The second was the homeschooling point. We agree that parents have a right to choose to educate their children at home in the domestic scheme. However, in this case, parents are not choosing to home educate their children. It's not a positive choice they are making on the hypothesis that the school is unavailable to them. The risk of them being forced to home educate results from their religious convictions and their socioeconomic status. And we'd submit that where a child is homeschooled out of compulsion and not choice, there is every likelihood that the education provided will be below the standard provided for in schools, particularly so where the community has an average household size of 6.5 children, and there are around 20,000 children potentially affected. The suggestion that this is a realistic option in this context, we say, flies in the face of reality. It's also notable in our submission that the Heredia schools perform an important community function, as we saw referenced in Zed and Hackney. By teaching children in a community, they foster a sense of their cultural and religious identity. They facilitate the learning and practice of Yiddish, an endangered language. And large numbers of Heredia children being homeschooled would be detrimental to the community. And we say both the Director of Education at Hackney and the government generally are concerned about this potential outcome. References for that are page 40 of the second bundle, Hackney, less oversight over their education, and page 699 of the second bundle for the Department for Education's concerns to this potential outcome. So we say that homeschooling, or the risk of homeschooling, ought to be treated as a potential detriment to this community that needs to be properly considered when making the proportionality assessment. I move on then to some brief points on the approach of the court and standard of review. On the suspect grounds principle, we emphasise that it's the ground that needs to be suspect, not the basis of any punitive solution. So the ground here, where there is a failure to treat differently, is squarely within suspect grounds territory at the intersection between race and religion. We agree with Sir James that the key aspect of SC for our purposes is the late 1580s of the judgment. We would emphasise paragraph 158 at 822, where Lord Reed says that very weighty reasons will usually have to be shown at the intensity.
Which paragraph?
158 at 822, my Lord. The sentence that very weighty reasons will usually have to be shown and the intensity of review will usually be correspondingly high if a difference in treatment on a suspect ground is to be justified. And we say the same must apply if a failure to treat differently in relation to a suspect ground is to be justified. This is an indirect discrimination analysis. So that usually is in cases which involve judgments of social and economic policy where a low intensity review is generally appropriate. See the discussion at the previous page. So we are in exactly the territory we submit that Lord Reid identified in paragraph 158 of SC, or putting it in the language of Lord Reid at 159, where a cogent justification is required. And that's what this court ought to accept in our submission to be the test. Are there very weighty reasons, or if this is different, cogent justification for not treating our community differently? So James relied next on paragraphs 206 to 208 of SC. We say those are fact-specific conclusions. The nature of the discrimination in this case is very different. It concerns a very small minority who are particularly vulnerable. Just for your notes, SC paragraph 187, at page 830, shows the status groups which got to the justification stage in that case. And they were women, vis-a-vis men, and children in households with more than 2 children compared to children living in households with 1 or 2 children. Both of those, of course, were very large status groups indeed. And so it's likely that if those claims had succeeded, the entire measure would have fallen, or at least would have needed to be radically revised. And so we say that the reference there being no legal standards by which the court can conduct the assessment in SC paragraph 208 has to be understood in that context, whereas there are very clearly, we say, standards that can apply in this much narrower context. If I can now pick up some points on which Sir James relied in terms of justification. First of all, the potential for the Haredi schools to move into the state sector. We say that's more theoretical than real. We would invite the court to note paragraph 38 of Ms. Whitehouse's first statement, at page 201, the first supplemental bundle, noting that no free school application waive is planned, so that the opportunity simply isn't there to even apply. And of course, we say that the issues that cause concern in relation to compatibility with the national curriculum and so on would be very powerful barriers for any school that did seek to move across, even if the option was there. And so more state-funded faith schools is only at most a potential and partial solution over a significant period of time, and it can't therefore be a weighty reason in the balance. In terms of the standards of the schools, could I give 2 references there to 2 example schools which have been anonymised in the government's evidence? They're at page 486 and 487 of the second supplemental bundle. The first of those schools has been rated requires improvement by Ofsted, but specifically in relation to the issues that we would expect, concerns about the teaching of protected characteristics and RSHE, which are noted to be common, as infrequent, in schools serving highly Orthodox Jewish communities. The second of the schools, at 487, 486 and 487, the second has been assessed by the ISI, the Independent Schools Inspectorate, and has met all those standards. And so we say these are not bad schools in the sense, in a colloquial sense. They are schools that serve a particular community and meet the standards of independent schooling, but may well not meet all the standards of state schooling. Again, not a weighty reason that goes in the balance in our submission. On the floodgates point, we say in any Claimants case there's highly likely to be a floodgates argument. It will always be open to others to say, what about us? That can't be a reason in itself to reject the Claimants case, because that would result that prima facie discrimination was always justified and would abdicate the court's role as the ultimate safeguard against discrimination. Turning then to cost, we do say that's important because the primary aim of the measure is to increase revenue. And we note again that the low fee exemption, the most plausible exception, would cost at maximum £30 million. At maximum, because the calculation does not discount for children who would be withdrawn from independent schools, children who would be supported by donations, or schools that would close. And we agree with Sir James that calculating this figure did not involve too many subtleties. We make no criticism of that. It's simply as a matter of fact, we say a maximum figure, which represents 2%, broadly, of the overall revenue the government believed it would raise. And on that basis, it was correct, we say, or certainly reasonable, for the Divisional Court to conclude that the cost of instituting the proposed carve-out would be modest, because on any view a 2% reduction is modest. We say that is a judgment this court is properly able to make on the evidence. It was also no part of the government's case that the revenue cost would be anything other than modest. It wasn't the major justification here. They majored on the points of principle and the practical arguments. And we say, ultimately, that a potential reduction in revenue of up to £30 million would not unacceptably compromise the objectives being pursued in the language that Sir James put forward and we agree with as the relevant test, certainly at the least intrusive means stage, we say also at the fair balance stage. On the practical considerations, Ms. Whitehouse's statement at paragraph 33 to 35, we say that doesn't begin to establish that these are very weighty reasons or cogent justifications. The low fee exemption was put forward, formulated by the government, considered and costed. There's no question it could be done. There would be some administrative burden, but not impossible or even unreasonably difficult in the administrative sense, and not a justification for not doing it, given the weight in the balance on the other side. So we come then to the policy reasons, and these are, of course, what ultimately persuaded the Divisional Court, we say, wrongly. Our submission is that the pluralistic and non-denominational education system in this country is an appropriate starting point for consideration, but it does not itself answer the particular characteristics of our community and the need to treat them differently. And we do say it's highly relevant that the pluralistic nature of the education system and promoting this is not one of the four objectives of the measure. That's the point that's made in our skeleton at paragraph 31, our appeal skeleton, under subground A. To the extent Sir James sought to link it to the aim of fairness for all, that doesn't involve, of course, treating everybody in the same way, where they are in materially different positions. That's too reductive. And so that there is an option available in the state sector that isn't religiously acceptable to my clients, that contravenes their profound religious convictions, in the phrase of Lord Justice Singh, which we respectfully adopt, is a point that must carry very little weight. We reiterate our reliance on the principle from Guberina, that's Authorities 58, page 1864 at 73, of course a tax case, as to the relevance of the status group being a particularly vulnerable group in society that has suffered considerable discrimination in the past, and that substantially narrows the margin. And we do say that the risk of legislative stereotyping, which prohibits the individualised evaluation of their needs, is precisely what has happened here. That risk identified in Guberina has been borne out. So James' headline submission this morning was, there's the education system, it provides education. We accept that is correct. There is an education system available, but it's simply not good enough as a justification for the failure to treat this marginalised and disadvantaged community differently. And we submit that cultural and religious beliefs are, in fact, being trampled on. Education is so central to the identity of this community and its faith, as Mr. Pinter's statement shows. And so, therefore, the means here are not proportionate to the outcome for our group. Addressing a point made by the Master of the Rolls in exchange with Sir James, we say the low faith school exemption doesn't do any real harm to this pluralism policy aim, because it's solely for a small minority group which has very good reasons for seeking their own schools, including an extensive history of persecution and anti-Semitism. And such a general policy aim as this has to be capable of giving way to the compelling claims of minority groups to avoid rendering the protection from discrimination in Article 14 entirely nugatory. I can take the parliamentary consideration point very quickly. It's simply a factor which may be relevant, and we say relevant to the width of the margin, not a justification in itself. That's SC paragraph 182. And I would come back to conclude to the issue of anti-Semitism. The fact that anti-Semitism is a real-world experience for my clients is barely reduced in force on our side of the balance by it not being permitted behaviour, as Sir James submitted. The fear of anti-Semitism was mentioned by the Divisional Court in the annex to the judgment, but we say that needs to be given real weight in the proportionality balance. The Divisional Court did not do this in our submission, and we respectfully invite this court to remedy this, and indeed to give careful consideration to all the factors on the community side of the balance in deciding whether the government has discharged its burden of justification. Ultimately, we say the best the government can do is say that other possibilities exist for our community to receive education. In state schools, which will not be religiously acceptable to them, or at home in large and disadvantaged family settings. None of these in our submission amount to the kind of weighty reasons required for the failure to treat differently our community, who are in a remarkably different position than other private school users, as a result of their profoundly held religious beliefs and their community's historical and present-day experience of anti-Semitism. My lords, my lady, in our submission, therefore, the government has failed to discharge the burden of justifying the failure to treat the Haredi Jewish community differently in this case. And we invite the court to make a declaration of incompatibility accordingly, unless I can assist further.
Thank you very much.
Grateful.
Yes.
Just have a minute while we sort the lectern out. My lords, my lady, starting first with the submissions made by my learned friend Sir James Eady, and he starts off by concentrating on Article 2 of the First Protocol and the nature of the right and the state's obligation as he sees it, and references made to the case of Begbie and the Lord Grey School to establish what we say, if that's the limit of the right, it is minimalist interpretation, which is on a par with the position that the government parties adopted in the court below, but simply isn't correct. The obligation is not simply an obligation on the state to provide free schooling, and we saw this from the Belgian linguistics case and from Catan, where the primary right guaranteed under the first sentence of Article 2 of the First Protocol is the right to access existing institutions. And Catan also confirms that this right applies to private as well as state educational institutions. And then when we get to Shaheen, we saw that the court, the European Court, clarified that the right to access applies to any, and that's the word they use, any existing institution. So again, it's not to say that the right guaranteed under Article 2 of the First Protocol is simply a right of someone to have a place at a state school is a small part of the story. There's much more to the right than that. What we say is that the right of access means that there is an obligation not to impede access. And this means that the government can't impose education taxes. And we say that the key error of the Divisional Court is summed up at paragraph 253 of the judgment, where they claim that Article 2 of the First Protocol only protects the right to access education system the state chooses to provide. And I made this point in submissions, and it's clear that this is the dividing line between the two positions. Does Article 2 also extend to private educational facilities? I should mention, I did mention, I repeat, the government parties below maintained that Article 2 of the First Protocol didn't apply to private schools at all. So we've had a little bit of movement, but not enough, we say. There isn't a recognition of the broad scope of the argument. The cases referred to don't help my learned friend. Lao Tzu was not about access to school, it was about crucifixes on school walls. So there's nothing to be derived from how the court framed the argument there, where it was about state schools and whether state schools could have crucifixes on the wall. Unfortunately, the case of Chancellor and Denmark is not in the bundle, but it's an obvious point, but each state will have its own ways of meeting the obligations. We shouldn't rely on what's said there to imagine that the same principles that apply to this country. One of the features there was that we don't have any more detail about that, but one of the features was that the state provided 80% subsidies for schools, private schools that didn't want to teach sex education. So there was a suggestion that this might have helped meet the concerns under the second sentence of Article 2 in Kelsen. Conrad in Germany doesn't assist either. Page 1458 of the authorities' bundle, right at the beginning, it says these claimants, yes, they wanted to homeschool and they weren't allowed to. They rejected private schooling. We're not saying that. We're not arguing here for a right to homeschool. We're arguing for on behalf of the private schooling. That's precisely what was rejected in Conrad. So we say that doesn't help either. And we note, incidentally, that homeschooling was not, the possibility of homeschooling was not accepted as a means that the state could discharge its duties under Article 2 of the First Protocol. And we know that, and it's for this country, because that was a case of Campbell and Cossens, where, of course, the possibility of homeschooling was always open to the parents. The state says, look, you don't want to come to school because you don't want your son to have the risk of being disciplined. Well, fine, homeschool. But that wasn't an answer to the applicant's objection in that case. As far as the international instruments is concerned, all treaties will have general and aspirational language, but what's clear from this language is that the rights apply to private schools, and that's the point that we want to underline, and it's the point that goes contrary to the submissions government parties made below and to a certain extent are continuing to make now. The government continues to maintain that there's no distinction between taxing and subsidising, and in my submission, in fact, the casuistry is to suggest that there isn't. This is a very important difference and distinction recognised by the European Court between negative and positive obligations on a state, and the difference between taxing and subsidising fits precisely into that dichotomy. There may not be a positive obligation to subsidise. There is a negative obligation, we say, that's the minimal obligation, not to impede access to education. And that's the distinction. And incidentally, it's a point which went by the wayside, but by Lord Singh raised the issue about taxing schools out of existence. I say it went by the wayside because it was an argument we used right at the beginning of this litigation, when the challenge wasn't to legislation, but was to the House of Commons resolution, and a very interesting constitutional questions arose as to whether a House of Commons resolution could interfere with fundamental rights. And this, to some extent, is why the Speaker of the House of Commons intervened in the case and is still a party. We maintain that once the principle that taxes can be applied at any rate, any sort of impeding of the right to education, then it is open to the state in principle to close schools down entirely by imposing punitive taxation. And we say this is a necessary corollary of conceding the principle that taxation is acceptable. It may be a black letter point, but we say it's a logical point, and it's one that follows. The movement to the state sector, not clear whether my learned friend was addressing that possibility to the Haredi schools or whether it applied to us, but I hope we made clear by reference to JR 87 that that's simply not an option for the sort of education the evangelical parents are seeking in this case. And also to point out that this sort of long-term solution to a problem is again precisely what was rejected in Campbell and Cosms when the United Kingdom said, well, we're looking to abolish corporal punishment. And the response of the court was, this is unacceptable. It's the problem that these parents face now, the problem these children face now. Matters not that there's a medium long-term solution to address this issue. So even if it were possible to obtain state funding, and the evidence before the court is that there's no anticipated wave of application at the moment for any sort of state funding. So even if one wanted to and was prepared to give up on Christian principles that the parents want, it just wouldn't be practically possible because the state isn't offering this possibility at the moment. My lady, Lady Falk, raised some issues about, or there was some discussion about the money bill and the legitimacy. Again, these were issues which were raised at the beginning, interestingly, and I can't put any or great emphasis on this, but it is worth considering that we do have a situation where, in terms of the passage of this legislation, is rather different from that of most legislation. It wasn't subject to the possibility of the House of Lords blocking it. It was a money bill. And it's also significant, and these figures were in our statement of facts and grounds, that the Labour Party, the government party, got into power with a very small proportion of the vote, 20% of the national vote. If the court, it's a very different matter where a challenge to this sort of legislation is concerned in that context than one in which there's been proper and full scrutiny from both houses of Parliament on a measure, rather than something which is pushed through by a party which quite properly, this is how our system works, but this is what's happened. A party obtaining 20% of the total vote obtained a majority, and it's now sought to, we say, to abridge fundamental rights on the back of that, of the power that it obtained. As far as the consensus is concerned, and there's been a lot of discussion about what factors affect the margin and what level of scrutiny is necessary for the court to impose. But if one looks at SC at page 809, and my learned friend read what was over the page, but if we look at the top of page 809, we see this is 1153. So the third is that the width of the margin of appreciation can be affected to a considerable extent by the existence or absence of common standards among the contracting states. And so we say, whatever else affects the width of the margin of appreciation, this consensus which exists, and it's a universal consensus by the United Kingdom against the taxing of education, is highly significant and will, we say, applying SC to a considerable extent, affect the margin of appreciation. The EU directive is, again, it's characterized as a measure to implement frictionless markets, but it simply can't be the case that those activities which are exempted in Article 132 are necessary to ensure a frictionless market. Is it necessary to exempt the supply of services by dental technicians, as is done there, or the supply and services of goods closely linked to welfare and social security work of children? Is that necessary to ensure a frictionless market? We say it isn't. It's clear that what these exemptions embody are a set of values, a shared set of values, which have been, we said, solemnized by the law. So the fact that they've been put into law is highly significant, because the recognition of these values is now so universal that it was felt appropriate to put them into a binding law and to bind all the countries in the European community. The question was, is there a challenge to the timing of this measure? And it said it's not clear that this is still pursued, this under proportionality. We say, yes, it is pursued, very much so. And we note that, and this is a challenge to the fact that this legislation was imposed in the middle of an academic year. And causing very big disruption for many people, and also ensuring that it's very difficult for parents to remove their children halfway through a year, even halfway through their course of studies. And the only justification for imposing a tax midway through the academic year is to obtain more money. There's no other justification. We can see in the Treasury notes, which we looked at before, and in second supplementary bundle, page 1010, where we've got the estimated numbers of pupils. We looked at this table before who were going to have to pull out of private schools, and the estimate was 3,000 in the first year, and then rising to 14,000 in the second, and so on. And the Treasury there says where this change occurs, straight after the table, the government expects much of it to take place at natural transition points, such as when a child moves from primary to secondary school, or at the beginning of their GCSE or A levels. And that's clearly the case. That's why it was anticipated that the students wouldn't all leave at the beginning. There were these captive students, and the parents would be forced to carry on paying those fees. Otherwise, the children would have suffered grave prejudice as a result. So we do challenge the timing of this measure, and that's remained part of this challenge, particularly on proportionality. The following paragraph on that page 1010 says another important point which answers, perhaps, and I may have misunderstood, but as I understand an inaccuracy in the figures that have been presented. And this says this, alongside the revenue raised, and the revenue raised figures are the ones we've seen, the 1.5 billion, they're rising. This policy will result in some additional costs on state schools due to pupil moves. And then they say that those will go up to 270 million on this paper. And then the figure's been rounded up in other documents, 300 million. And the point is this, if someone leaves the school, the Treasury will obtain a little bit less money, which is the VAT that they would have got on those school fees. And if a low-cost school leaver, it's not going to be very much. But if that low-cost school leaver then has to go to a state school, then the latest figure is £8,500, which is the cost of education, suddenly has to be met by the state. And so the question, and that's why there is that loss, and that's why the more students who leave, the greater the loss will be. And that's why I mentioned Professor Leach's witness statement where he sets out the various surveys, and some of them show that a very great number of students will leave. I have to correct one aspect of the figures that I gave yesterday, which I realised was incorrect. I said that there were 500,000 students in private education. There were 500,000 students in ISC private schools. The real figure is 600,000. So again, if a quarter of those leave, which several of these surveys suggest, it is a possible figure. That's 150,000 students leaving leaving private education, which for the vast majority of them, the state is then going to have to pick up the tab. It very soon gets to the point where there isn't going to be any money because it's going to cost more than those students who are still left paying VAT will generate. And the question is there any principled reason why there should be a low-cost exemption? And we say yes, that is a principal reason, because the impact of a low-cost pupil leaving private sector and the very small amount of VAT revenue which state will lose, or rather gains from those students, is instead greatly eclipsed by what it will then have to pay when they go to the state sector. And I wanted to turn to the submissions made by my learned friend, Ms. Hammett. I first would refer the court to Authorities Bundle, tab 6, page 76. And this is section 10A of the Academies Act, which is which relates to the payment of fees for boarding charges at academies, and also shows, incidentally, an exemption system which exists there. So the presumption is that people being educated by the state will have to pay boarding fees, the parents will have to, but there is an exemption system where the local authority intervenes if they're not able to pay. We are not objecting to the existence of this regime. In fact, it's an example of a sensible approach, and where it ensures, where the legislation itself ensures that people who can't pay are going to have their fees covered. What we do object to is the fact that these fees are without VAT. And again, we mentioned this is not some poor struggling state school, as Peter Lowe in his first witness statement points out, the highest paid headmaster in the country, I think the figure was £560,000 a year, is an academy headmaster, and that money is paid for by the state. It's not the headmaster of Eton. We are told that the arguments on discrimination vis-a-vis the academies have only been raised now, and they didn't come up below. I would refer the court to paragraph 136, page 586 of the core bundle, and that's our statement of facts and grounds where this argument was raised. And then again, in our reply submissions before the court, and that's at page 484 of the core bundle, paragraphs 22 and following, and that's set out in some detail. Now, we were given permission by the divisional court to make written submissions in reply because we didn't have any time to make any oral submissions because the other parties had spent so much time. So we put in those written submissions, and they're there, and the arguments set out there as well. So it's nothing new. We're told that then in any case this doesn't affect us because none of the schools are boarding schools, and that's true. But that doesn't mean that they may not wish to become boarding schools in the future. And in fact, the Wycliffe School memorandum, which we looked at before, on page 146 of the supplementary reference bundle, anticipates the possibility, expressly anticipates the possibility of the school becoming a boarding school. It's not, having conceptual, to an extent, having conceptual problems understanding the objection to the claimants making claims in their own name. In fact, quite the opposite objection was originally made, that we were trying to, rather that all the claimants were trying to challenge the legitimacy of the Act. And the response we gave then at the outset of the litigation, in defence of our position, the response we give now, is that we're making claims as individuals. And when one goes to Strasbourg, that's how claims are made. What Strasbourg has repeatedly said, and we have it in, I can take the court to the case of Hurst where it pops up, and the court will have to excuse the Latin term that the court uses, but they say Strasbourg court is not for actio popularis. It's not about arguing you don't bring claims on the group. You bring claims about your own personal situation. And in Hurst, at page 1392, paragraph 72, the court addresses that point squarely, and because the objection was made by the government, saying, look, you're objecting to the legislation itself, and the court says no. At the bottom of that page, the court does not accept this criticism. The applicant's complaint was in no sense an actio popularis. He was directly and immediately affected by the legislative provisions of which complaint is made. And that's simply the case in our claim as well. We're affected by these provisions. And and that was an Article 14 claim as well, I hasten to add. It's not that it was a claim under the substantive article. Article 14 claims can be raised if you are affected yourself by the provision, and the court will then determine that you've been a victim of the violation. We're told that there's no evidence of Christian disadvantage, and we still maintain that we don't have to show group disadvantage, but there is plenty of evidence before the court. It's just we didn't expressly rely upon it. We've got two witness statements from Steve Bigu, who was president of the Christian Schools Trust, an organisation which encompasses the majority of the Orthodox evangelical schools which are represented in this claim. And they're at pages 99 and 184 of the supplementary reference bundle. We also have surveys from the school teachers, the head teachers, on what the impacts were going to be. I mentioned these before. Pupils were going to have to leave school. So there's the criticism, just to make it clear, where we said there's no consideration of the ability to pay. There's no consideration either in the legislation, obviously, nor in the technical note, which was presenting the legislation. We're not making any comment about what sort of parliamentary consideration there was. The government chose to present this legislation through the technical note, and legislation as it was enacted simply doesn't contain any consideration of ability to pay. We're told that the court fees cases are not analogous because people can always open their own schools, and apparently that somehow shows it's not an analogy. Well, we say that doesn't show that at all. It wouldn't be an answer to say, well, no one's stopping you going from court. You can, to an impecunious person, you could establish a fundraiser or go and get a bank loan. You've still got the right to go to court. That's not the point. The point is about the government putting obstacles in the path of people trying to exercise their rights, and also of and not taking into account the individual situations. And those were the points we were making. When we suggested, I hope I made it quite clear, I was suggesting a number of possibilities. It wasn't to commend any of these to the court, and certainly it's not the court's function in making declaration of compatibility to then tell Parliament they need to adopt either 1, 2, 3, 4 or 5 or a combination of these solutions. It's just to show that there are solutions available, and they would have constituted any one of these less intrusive means, and that for those reasons the proportionality requirements, particularly under stage 3 of bank mallet, but also stage 4, wouldn't be met by this VAT measure.
Thank you. Thank you very much. Good. Well, thank you all. Did you want to say something?
Not at all. Really just not leaving you unattended.
Thank you. Well, we're going to reserve our judgments in this case, and in due course we'll hand them down and let you have a draft. But because of the obvious political sensitivity of the case, we're very unlikely to let you have very long for corrections. So it's likely to be something like 24 hours, but we will give you, before hand down, we'll give you notice of when it's coming so that each side can have counsel available to look at the draft and provide typographical but not substantive, please, corrections. In addition, you should use the order, the judgments to agree costs and the order. Because of the short time that you're likely to get to do corrections, you won't have to do that in the 24 hours as well. We'll set a time limit, which will probably be a week or so after hand down to agree the order and prepare any submissions you need to prepare in relation to costs and the form of that order. So it only remains really for me to thank counsel, to thank your solicitors, to thank indeed the clients for the courteous and helpful way in which the submissions have been prepared and presented very helpfully, and we will take time to consider the interesting issues that the appeal raises. Thank you very much.
Court rise at able.